We have an interesting lineup of speakers to discuss who governs, the government, parliament, or the judiciary. And who best to speak on this topic other than the former Attorney General of England and Wales, Lord Goldsmith. Lord Peter Goldsmith is Chair of European and Asian Litigation at Debevoise and Plimpton. He served as the UK's Attorney General from 2001 to 2007, prior to which he was in private practice as one of the leading barristers in London. As Attorney General, he occupied a position that is an intersection point between politics and law, as it combined the role of a minister, legal advisor, prosecutor, and upholder of public interest. Lord Goldsmith was made a life peer in 1999 and Privy Councillor in 2001. Thank you, Lord Goldsmith, for joining this session. Our next speaker is Arvind P. Datar, who doesn't need an introduction, but he's a senior advocate and who's also a cost and works accountant. He practices before the Supreme Court and other high courts and has also appeared in a bilateral investment treaty arbitration, which was held at the International Court of Justice. He has written and edited several books such as Kanga and Palkiwala's The Law and Practice of Income Tax, Ramaya's Guide to the Companies Act, and many more. He is the founder trustee of the Palkiwala Foundation and one of the most popular columnists on Bar and Bench. Our next speaker is Pratabhanu Mehta. His timely columns and editorials are the most awaited and widely read. Professor Mehta is a political scientist who has taught at Harvard University, Jawaharlal Nehru University, and the New York University School of Law. His areas of research include political theory, constitutional law, society and politics in India, governance and political economy, and international affairs. He's a past president of the Center for Policy Research and former vice chancellor of Ashoka University. Thank you, Mr. Pratabhanu Mehta, and thank you, Mr. Datar, for joining this session. And our moderator, the person behind putting all this show for us today, Gaurav Pachnanda. He's a panelist and moderator. He's a senior advocate whose practice before the Supreme Court of India and other courts and tribunals is focused mainly on commercial and corporate litigation, including domestic and international arbitrations. In the past, he has acted as the Additional Advocate General for the erstwhile state of Jammu and Kashmir. Gaurav is also a door tenant at Fountain Court Chambers, London. He writes extensively on legal topics and is a keen political observer. Thank you, Gaurav, for doing this.
Thank you very much. It's a pleasure.
Just to inform all our attendees, after the discussion amongst the panelists, there'll be live questions to the panelists, and some questions put in by the attendees in the Zoom chat will also be taken up by the moderator. And without any further delay, I'll hand it over to Gaurav to start the session. Thank you.
Thank you very much, Pallavi. Thanks a lot. Good evening to you all, and good afternoon to Lord Goldsmith, who's very kindly joined us from his current residence in France. Just to introduce the broad discussion points for us today, the starting point of our discussion has to be a comment or a statement that Lord Bingham echoed in Bob versus Manning, that the conduct of government affairs by the Prime Minister and the Cabinet, collectively responsible to Parliament, lies at the heart of Westminster democracy. But this does not end here. Judges in the Westminster democracy system have a power of judicial review. Last year, the UK Supreme Court struck down a recommendation of the Prime Minister in the case of Miller versus the Prime Minister, a recommendation of the Prime Minister to the asking that the Parliament be prorogued. The UK Supreme Court held that the recommendation was without justification and prevented Parliament from discharging its legitimate constitutional functions. There are several instances in India, for example, the Constitution 99th Amendment Act that amended the Constitution to create a National Judicial Appointment Commission for greater participation of government and Parliament in appointment of judges to constitutional courts. was struck down by the Supreme Court of India in 2015 on the grounds that the National Judicial Appointment Commission violated the basic structure of our constitution. The principles of constitutionality based upon which legislations as well as governmental action is tested are ever evolving in their nature. Some of them are well settled, but some of them continue to change according to the context and the situations in which they are involved. And the result of that often is the widening of scope of judicial intervention in the function of both government and parliament. What are the concerns that arise out of that situation? Sirvai, one of the great constitutional lawyers of our country, while speaking at the Chimanlal Sitalwad Memorial Lecture regarding the rule of judiciary under our constitution, expressed a view. I mean, he said that power is not property. Power under our constitution is but the means to an end, and the end is greater public good. Therefore, power must be exercised by whichever limb, either of the three limbs of government that is best suited to exercise that in a particular situation. So there are persuasive arguments for greater judicial intervention to fill the interstices of governance that otherwise compromise public interest in certain situations. But there are counter arguments and equally persuasive counter arguments against excessive judicial intervention, and somewhat sort of a different term that is used called judicial activism. For example, in the 2019 Reith lectures, Lord Sumption expressed a view that the demands for judge-made law, which require judges to express a view on matters that are ordinarily a part of collective moral judgment and regulate personal choices, adversely impact the ability of the judges to then enforce protection of personal rights, and this is a casualty of the rule of law. This happens sometimes just because of limited capacity, and matters relating to personal rights just getting deprioritized in the queue. Some would argue that the public interest litigation jurisprudence in India has had that effect. These are competing views on which I would welcome and now sort of request the panelists to express their views one by one. But I wanted to say that the purpose of this debate is not to profess to suggest any right answers by the end of this debate. The purpose is really to begin asking the right questions. My first question is directed to Lord Goldsmith, and I wanted to start with a topic that is of much interest in India regarding appointments to the higher judiciary. And what I wanted to ask him was two things. Why was the Supreme Court established to replace the judicial functions of the House of Lords in England? And how are judges now appointed as of today in the English legal system to higher courts, and particularly the Supreme Court?
Well, thank you, Gaurav, for that question. Can I say, first of all, I'm delighted to be on this seminar. I'm delighted to be speaking with my two very distinguished co-panelists. This is the closest I can get to India at the moment, of course, because of COVID-19. It's not quite the same, and I'm very much looking forward to coming when it becomes possible to travel again. But I'm going to do the best I can to feel that I'm in India at the moment. And I want to thank Bar and Bench too for hosting this and for the introduction that we had. So a lot has changed in the United Kingdom in recent years. You picked up, Gaurav, on two questions, and they really start with the question of why we now have a Supreme Court rather than what used to be the House of Lords, strictly speaking, the Judicial Committee of the House of Lords, because it was actually a committee of the legislative chamber, though the judges actually played no part in the legislative procedures while they were actually sitting judges. So this was formed as part of the Constitutional Reform Act of 2005, which was a major measure introduced by the Labour Party, which was in power at the time, really to create new powers and new procedures in a number of areas. The Labour Party removed a lot of the hereditary peers from the House of Lords. It decentralised government by passing a lot of powers to devolved administrations in Northern Ireland, Scotland, and a little bit even to Wales, and created the new Supreme Court. Now, in one sense, the Supreme Court was only a change of address. The House of Lords moved from sitting as a committee of the House of Lords in the Palace of Westminster to going all the way across the road to what used to be the the Middlesex Assizes. But it's turned out to be a lot more than that. The judges remained the same, with only a little exception. The people who appointed as judges remained the same. The powers absolutely remained the same. The right to go to the Supreme Court was exactly the same as it was to the House of Lords. But notwithstanding that, it has been quite a major, major change. And that isn't because the hierarchy and the anatomy and the architecture of the change was in fact to create more interventionist courts, but that seems to have been what happened. I think we'll come back to that when we discuss some of the important constitutional cases that we've seen in recent years. But let me just answer your question about appointment. Of course, the judges who were appointed to the Supreme Court, to the House of Lords, were very senior practitioners, almost always coming from the Court of Appeal. They were appointed by the Lord Chancellor, a government minister, but also a judge himself, it therefore looked as if they were appointments of government. Actually, they weren't particularly, and nobody has ever actually pointed to any bias shown by the previous members of the House of Lords sitting as judges in relation to cases, but the appearance certainly looked as if they were not independent of government. So that's the critical change. There are rules now about appointments of the top judges, the judges for the Apex Court. They're appointed on merit. People have to be people of good character. Neither of those propositions, I hope, are surprising. They do include a requirement now to encourage diversity in the range of persons available for judicial selection, which is significant. We now have the occasional, we do have some women judges. No one from any other minorities at the moment. The procedure is governed by, again, by the Constitutional Reform Act, and it involves a new commission, an appointments commission, which selects the practitioners according to the sort of rules I've identified from candidates who satisfy certain basic conditions. There are consultations that take place. The recommendation is then made to the Lord Chancellor, who still then has to make the appointment through Her Majesty. So what will happen is there'll be some further consultations. There's a very limited power really to make the commission think again, not to substitute names, but to make them think again. It's happened once or twice, and then the names go forward to the Prime Minister, who in turn sends them through to Her Majesty the Queen, and she makes the formal appointment. So that's essentially, it is different from the previous system, with limited exceptions, though the same people, I believe, have been appointed who would have been appointed before. We do now have one judge, Lord Burrows, who's purely an academic, and that's, I think, is a good thing. But he's the first of those directly appointed to the Supreme Court. Lady Hale, who was the previous president, had been an academic, but she'd also served, as it were, as a regular judge after a period of time as an academic. So that's it in a nutshell, and I hope that answers the questions that you put to me.
It does very much. Thank you very much, Lord Goldsmith. My next question is to sort of put broadly the same question or a similar topic to Mr. Datar, because the issue of appointment of judges by the collegium in India has come under severe criticism over the last few years. Unlike a judicial appointments commission in the UK, in India it's basically the judiciary that self-appoints and has primacy, at least in the appointments of judges in most cases. And I wanted to ask Mr. Datar what his views were on that, and whether he, and particularly the sort of decision of the Supreme Court to strike down the amendment regarding the creation of National Judicial Appointment Commission. Sir, I think your mic is muted.
Yeah, sorry. Thank you, Gaurav. And before I continue, I must thank Lex Witness and Bar and Bench for being the sponsors of this program. And Gaurav, thanks to you for taking all the trouble of putting it together and putting up with the three of us and our delays and so on and so forth. But it's been wonderful. Thank you, Lord Goldsmith, for being here, and thank you, Pratap, for also joining this program. It's a delight to be on this panel. Now, before I give you my views on the Supreme Court decision on the National Judicial Appointments Commission, I must point out that I was also one of the counsel for the petitioners. And I do sincerely believe that it is a correct decision to strike down that particular law. Well, the collegium system has come from the 90s, and it came basically as a matter of necessity. Before we criticize the NJAC judgment or the collegium system, it's better to just in one minute or two understand the history of the appointments. From that, till Mrs. Gandhi came with this policy of supersession, there was really not much controversy on appointment of judges. In fact, the Home Minister, Govind Vallabh Pant, in 1959-60, and later Mr. Ashok Sen as the Law Minister, made a statement in Parliament that with the exception of just one judge, all the recommendations of the Chief Justice were accepted. He also mentioned that even at that point of time, the Chief Justice of the High Court and then of the Supreme Court would consult the executive, the Home Ministry, the local Chief Minister, the Governor, and the appointments were made. So there was no controversy till the supersession started. Then you had the transfer policy, and one thing led to the other and led to a lot of rift between the executive and the judiciary. Then in 1982, the pendulum swung in complete one way in favor of the executive, saying that the Supreme Court is just going to be a consultee. It doesn't mean concurrence, doesn't mean this and that. And then you had the second judge's case and the third judge's case, which put the collegium in place. Now, frankly, if you take the empirical evidence, I don't think there is any evidence. I mean, when we did the NJC case, I tried to find out the various sources. There's not a single study which points out that the collegium system has produced a lesser able number of judges as compared to the list. There's no such thing. And I would frankly say that practicing from 1980, I think that the collegium has given us some outstanding judges, and the collegium system has also been able to block the appointments of some persons to the Supreme Court and to the High Courts would have been totally undesirable. But having said that, I would not say that the collegium system is free of all defects and it's the perfect system. No, I would not say that at all. It has got its own problems. But I thought that it would be better, it would be easier to make minor changes, iron out the creases, so to speak, in the collegium system than go for an NJAC. Now, I personally feel that ultimately, what is your objective? Your objective is to appoint the best possible people to the higher judiciary, whether it's the High Court or the Supreme Court. You know, you don't have a written exam, you don't have an interview, so you just basically trust your judges to select people or nominate people who will be assets to the bench, who would do justice, and the next generation would have an equally competent number of judges. So if your goal is to have the best possible judges, then whether it's the collegium system or the NJAC, these are all means to that end. So it doesn't really matter in that sense what it is. The whole difficulty comes when your intention is not to appoint the best possible judges, but to dominate or control the appointment system. And that's what the NJAC did. There's been a lot of criticism of the NJAC judgment, and India is the only country where judges appoint themselves and the executive has no role to play. I think it's a complete misinformation and it is factually incorrect. Let me just mention two things here. As far as the NJAC proposal was concerned, it was flawed in terms of the constitutional amendment and fatally flawed as far as the statute was concerned. In fact, if you take Article 124A, B, C, which was introduced, you had a completely bizarre system of appointment. You had a committee consisting of even number of judges. There was no provision for a casting vote. You had a veto provision. You had provision for two eminent persons, and you did not know who the eminent persons would be. And in fact, in the Supreme Court, the Attorney General said we could be some agricultural scientists as well. So it was completely bizarre. And how do you have a veto system? And if you go to the NJAC Act, I mean, without exaggeration, it had very, very, very serious flaws. And the absolutely unacceptable proposition there was the NJAC would be governed by regulations. These regulations would be notified in the Gazette. All right? And the worst part was this notification had to be placed before Parliament under Section 13 of the NJAC Act. And Parliament could amend, nullify, abrogate these regulations. So ultimately, you had a set of regulations which prescribed, mind you, the qualifications, the procedure and all that for judges. It was by a gazette notification, just subject to parliamentary amendment. So you had completely destroyed any concept of independence, and I really feel it was perfectly justified in, Supreme Court was justified in striking on the law. And I must also mention that Mr. Fali Nariman was leading the petitioner's side of arguments. And he repeatedly pointed out that we are not supporting the collegium system. We are not here to canvass the continuance of the collegium system. We don't mind any system. We said, go by the recommendations of the Justice Venkatachala Committee, a committee of 7 people where judges would be 4 and the others would be 3, including representative executive. So that's what we said. But the government refused to. We also suggested amend the law and we'll withdraw our case. But they were adamant on continuing it and ultimately said. Now, the second myth, which I've been finding in some articles and some statements, is that, the collegium system has to be executive, has no say, and so on. I think that's also completely wrong. The executive has a very, very large amount to say. In fact, if you see the appointment process, the pre-appointment process where you select a candidate and you refer him to the Intelligence Bureau for comments on the character and the antecedents of the judge, the proposed candidate, the executive has a major say. Even today, if there is a strong objection by the executive or by the chief minister of the local state and there are genuine objections, the appointment is not made. The collegium judgment itself says that the collegium makes a recommendation. If the objections are strong and then on the second round the appointment is not unanimous, he won't be made. So it's completely wrong to say the executive has no say. And not just this government, but the previous government also. I know cases where when I was a junior, appointments were not made for 9 months. They had gone through the collegium, but they were just not made. The last mile is the executive. If it does not issue the notification, you can make the most wonderful recommendations and it could be completely stymied. Today, more than 200 appointments have been cleared by the collegium, but not appointed. So I think that the collegium system should continue. What we can do is we can tweak the system. And this is a better system which has worked for 25 years, improve upon it. And instead of completely throwing the baby with the bathwater. Thank you.
Thank you very much, Mr. Datar. That's a very helpful perspective. I wanted to come back to Lord Goldsmith before I have a very interesting perspective on this from Mr. Pratabhanu Mehta. But I wanted to ask Lord Goldsmith about what are the repercussions, according to him, of the judgment of the Supreme Court in Miller versus the Prime Minister on the concept of constitutionalism in the UK. Because this is a decision, a landmark ruling in which, as I mentioned earlier, the court intervened to prevent a recommendation of the Prime Minister to the Sovereign from asking her not to prorogue Parliament. So I wanted Lord Goldsmith's perspectives on the impact of that decision on constitutionalism in the UK.
Well, there are actually 2 Miller decisions. They're both cases brought by Gina Miller, who's a member of the public, though a very active one politically. And both of them concern the royal prerogative. The second one has got, I think, major constitutional implications, although if you read it one way, it's actually completely standard, normal, nothing special about it. I need to say something about both of them. So the first Miller case, which is in 2017, really was about the relationship between Parliament and the executive. And that was this, that under and this is all to do with Brexit, which has been dominating political life, sucked all the air and oxygen out of everything else. So this was about whether or not it was for Parliament to decide whether to send a notice saying, we quit to the European Union, or could the executive do it without parliamentary say-so? And it got to the Supreme Court, who decided that it needed Parliament to say so. And that's interesting because until then, generally speaking, people had thought that the exercise of the royal prerogative didn't require Parliament to be involved. That's the traditional way that the monarch actually had operated. There were 2 classic areas where Parliament didn't get involved. The exercise of international relations, so going to war or making treaties, and some other areas too. And these were not something that Parliament had a role in. This has all changed in relation to going to war. Parliament has been asked about it, not that any law required it, but it's now become a convention that Parliament has to be asked its opinion before military force is used, unless there's some great urgency in relation to it, a sudden attack or something of that sort. In relation to making treaties, that's the other area. And it's interesting because I currently chair a House of Lords Select Committee on international agreements, and we're now scrutinising all international agreements which are made by the United Kingdom. But going back to Miller, the second Miller case determined a different question, which was whether or not the Prime Minister, technically it was a recommendation, but of course it was really an exercise of his judgment and his power, could prorogue Parliament, bring Parliament to a stop. Now that was a major political issue because the opponents of Brexit wanted Parliament still to be able to operate so that it could actually pass laws or pass motions to prevent Brexit or at least to delay it. And there was a lot going on during that period. I sit as a member of Parliament as well as being an active lawyer. And so I was involved in these events. And what happened there was that there were two conflicting decisions. One of what is effectively the Court of Appeal in Scotland, not called that, and one, the Divisional Court in England and Wales, about whether the courts could intervene in decisions to prorogue Parliament because they were absolutely a matter of it was thought, the royal prerogative. What the Supreme Court said, and interestingly, unanimously, which indicated how strong they believed their position was, that if let me just read, I think it would be helpful to do that, just read the critical paragraph from the judgment, which I have here. A decision, the court said, to prorogue Parliament, or to advise the monarch to prorogue Parliament, will be unlawful if the prorogation has the effect of frustrating or preventing without reasonable justification the ability of Parliament to carry out its constitutional functions as a legislature and as the body responsible for the supervision of the executive. In such a situation, the court will intervene if the effect is sufficiently serious to justify such an exceptional cause. But what's interesting is they didn't actually get into the merits of whether there should be a prorogation, because that would have been, as it was seen, to interfere in the decision by the executive. What they said was, the executive has presented no reason for doing this. And everyone knew what the reason was. It was in all the public newspapers, in all the public discourse. But the government, I think very, very badly advised by, dare I say it, the then Attorney General and the others, didn't put in any evidence as to what the reason was for prorogation. And so the court was able to say, as courts sometimes do, well, we don't know what the reason is. No evidence has been put forward. So all we can say is there's no evidence there, and therefore there is no justification of what's been done. Now that's, in one sense, is a very classic, simple way that judges decide things. What's the evidence? Oh, there's none. So there's no reason for doing this. Of course, ignoring the fact that everyone knew what was actually going on. So I think it has had major changes, not so much because of the way that the case was decided, but because it was decided. And I think now, from now, we will always recognize that the courts are capable of intervening even in matters of high political moment, as long as they can see a legitimate basis for doing so. Now, in days when we have a government which is quite evenly balanced with the opposition, so that the government can't just do what it wants, that may not be so important. In areas where the government is in a commanding position, as Mr. Boris Johnson is at the moment, following the last election where he got a commanding majority, then I think we could see more intervention by the courts. So, big change, though no change.
So what struck me when I read that judgment, Lord Goldsmith, is that there is also impliedly in the analysis of the judgment, there is a recognition that in appropriate cases, there might exist a justification for interference in the constitutional functions of a constitutional authority. It is, and I think, of course, having, that is what flows from the analysis. And of course, there is no opinion expressed as to what would be the level of justification. But I thought that is some kind of an exception that needs sort of analysis of the merits of each case, which were absent in that judgment.
Yes.
Gaurav, can I just ask a question to Lord Goldsmith, if you don't mind, with your permission?
Yes, of course, sir.
Interestingly, Lord Goldsmith mentioned that one reason was there's an absence of evidence. Now, there are two questions. Suppose the government were to give a reason. Now, the entire public knew what was the reason. He didn't want the entire whole thing to be scrutinized by Parliament. He was in a hurry to get the whole thing through. So the public knew that the reasons were X and Y. But suppose the Prime Minister had given reasons A, B, C, which were not the real reasons. Would the Supreme Court still have interfered, saying it's a mala fide exercise of power? Number one. And secondly, do you think? And secondly, what I want to know is the judgment, especially in para 57 and 58, refer to constitutional principles. It's contrary to constitutional principles. Now, what are these constitutional principles? Do you think that in the years ahead, the UK courts are going to involve what are these constitutional principles?
Well, you're sort of asking me, are we going to get a basic structure? A doctrine I've always admired. I relied upon it in the Caribbean to say that they should have a basic structure in our cases. But the fundamental question is, could there be a legitimate justification? Well, obviously, if you say without justification, but none was offered here, that opens the possibility that there could be. What they would have said if the real reason had been put forward, we don't know. We know what was said in the courts below, or at least one of the courts below, in the divisional court. They said, no, that's a matter for the Prime Minister. It's a matter for the executive. If they think that it's time actually for Parliament not to sit, that's for and have a general election. I mean, what more political decision could there be, they would say, than to determine that there should be a new election, which used to be a matter, purely for the Prime Minister of the day. We've changed that in other respects. So we don't know until it happens what justification would be accepted. Obviously, the government thought that there was a risk that they would be the reason would be looked at, and with justification, because a lot of people were looking at the prorogation, the longest prorogation that ever been, the number of other superlatives attached to it. So they obviously worried that the Supreme Court might have interfered and said, well, that's not a very good reason, so we don't accept it. As to whether this is establishing constitutional principles, well, yes, it is. But they've always been there. The constitutional principle here is that it is the role of Parliament to pass laws. It is the role of Parliament to supervise the executive. And what the executive were doing was interfering with that. Nothing wrong with that. Not actually controversial. Not since 1689, when we passed the Bill of Rights, when we had the glorious revolution of our own, which I might say something more about later. So you have to watch this space to see if anything else emerges.
Thank you, Lord Goldsmith. My next question is to Professor Mehta, and I wanted to ask him if he thinks whether executive power can, in effect, in reality, be tamed by either the judiciary or by the legislature. And I wanted to ask that question particularly in the context of the role of Indian Parliament in our democracy in recent times.
First of all, thanks for having me. It's a bit intimidating being with this distinguished panel. So since I'm not a lawyer and therefore not burdened by either the majesty or formalism of law, I'll broaden out the discussion a little bit. I think you've asked a really, really important question. And I think we have to look at sort of two different aspects of this question, right? One, I think it's fair to say, on average, that executive power and almost untrammeled executive power has grown in the Indian Republic exponentially. There were elements of it that were always there. By the way, this is true of democracies more generally as well. I mean, as a political scientist, this observation everyone makes. Now, there are 2 or 3 long-term causes for it. One is, of course, the creation of national security states, which always license incredible executive discretion over our lives and liberties. And in holding the state accountable, in those circumstances, both the judiciary and the parliament have abdicated their duty. I mean, the fact that India has sedition laws in the book, the fact that we have UAPA, the fact that, pretty much, right, the state can do what it is doing in places like Kashmir without any judicial or parliamentary accountability. And this goes back to the Supreme Court ruling on the Armed Forces Special Powers Act in the 1950s, right? So as national security states grow and they widen the ambit of national security definitions, by definition, the power of parliament and judiciaries, it takes a brave judiciary to actually take a stand. And unfortunately, judiciaries let us down when we needed the most. The second thing that is, I think, complicating is that the administrative state has grown extraordinarily complex. Mr. Datar knows a lot more about this. And one of the consequences of the growth of the administrative state is that it takes an extraordinarily sophisticated parliament to actually hold the administrative state to account in the way it could. In fact, this is an argument even being made in the US case, where you have much stronger committee systems that the administrative states, by its very nature and character, empowers the executive in more ways than we think. So these are two, in a sense, long-term things. But in the Indian case, I think there are two specific challenges with Parliament that I think we haven't paid sufficient attention to. The first, I think, and frankly, this is something we don't have in any of our textbooks on democratic theory, any of our textbooks on constitutional law, which is the role of political parties in a democracy. Now, one of the big challenges and why legislatures have effectively become rubber stamps to the executive is that it's not clear what the role of political parties in our political system is. They formally don't have, as it were, you might say, constitutional statutory role. But effectively, that is the conduit through which political power is exercised. And one of the unfortunate consequences of the anti-defection law was that not only did it disempower individual legislators, it in a sense was a way of institutionalizing the power of party leaderships, right, over their own constituents in unprecedented ways. So the net result is that it's very hard to think of Parliament as an independent entity unless a political party lets its function as such. Right? When if the anti-defection law had been confined to a confidence vote or perhaps a money bill, it would have been one thing. Right? But as we are seeing it play out in the courts right now, the ambit of the anti-defection law has been interpreted in a way that it effectively makes the individual legislature sort of very, very disempowered. The second aspect, I think, is the functioning of the institution of Parliament itself. So one of the most extraordinary things about the Indian Parliament, right, is, it does a good job sometimes in public debate, Parliament sittings. Obviously, legislation has to go through committees. There's a bunch of functions it's performing on the surface reasonably well. But the two amazing things about the Indian Parliament is, one, it has no settled procedures of its own in terms of when it is that members can get parliamentary debates, right? Unlike the House of Commons, which actually does very clear rules, right? There have been demands for years and years that unless Parliament, in a sense, reduces the Speaker's discretion, if you like, right? How can it, in some senses, generate political accountability of the executive? The second is the weak role of committee systems. Unlike the House of Commons, right, where you can think of major inquiries conducted by Parliament against executive power, including on foreign treaties, including the debate on the Iraq war. There's almost no instance where Parliament has been able to exercise its core accountability function. The corruption scandals, the 2G scandal, if a CAG report comes to Parliament, Parliament should be able to take it up and hold the executive's feet to the fire. But it can't do it because of the nature of the party system, right? And in a sense, the court steps in. So the institutionalization of our Parliament through the party system has effectively rendered Parliament toothless. I'll just make one last point. I know we have several other questions to cover, but, and I say this with all due respect, right now, I cannot in good conscience tell you what Indian constitutional law is. I'm always amazed that lawyers and judges act as if there is such a thing, right? The discretionary behavior not subject to public reason or rules of accountability of every single branch of government, including the judiciary, particularly the Supreme Court, right, has effectively negated all the basic rule of law characteristics of constitutional law, right? There is no integrity of process. There is no predictability. There is no sense of where stare decisis applies, where it doesn't. Even things as basic as Evidence Act are being violated, right? We are at a very different stage in Indian democracy, where the discussion of accountability cannot be conducted in purely formal terms of the legal fraternity and all of us pretending that these forms, it's almost like a pantomime display of forms. Right? Who is the Supreme Court? The Supreme Court right now is one justice. There is no Supreme Court. Right? How do we expect it to hold the executive to account, right? And I think we have to, in fact, I think seriously ask, change the frame of our discussion and ask, are we in the kind of jurisprudence that was more appropriate to crisis republics like the Weimar Republic, right? With extraordinary expansion of authoritarianism, with extraordinary expansion of majoritarianism, completely unchecked by parliament and judiciary. The pieties of English law and our Blackstone and the fictions that we are teaching our students in law schools, frankly, do not describe the reality of law, accountability, or power at the moment. And lawyers will have to be much more creative in responding to this challenge.
I wanted to ask Mr. Datar if he had a perspective on that analysis, and then I have a follow-up question for Mr. Datar.
Yes, well, I heard the criticism of Pratap. Well, I wouldn't say the picture is as dire as he thinks it to be. There's a lot of good work being done in the high courts. There are still a lot of good work being done. And what happens, unfortunately, is, as you say, our Supreme Court is polyvocal. Because of the judgments of a few courts, it appears as if the Supreme Court has completely become dysfunctional, which may not be true. I'm not saying that everything is nice. In fact, some of the judgments leave much to be desired. They should have been perhaps more oriented to upholding the rights of citizens. It has not happened. But he's right in the sense that perhaps there should be a greater amount of protection of citizens' right at the Supreme Court. And also it's a matter of optics and also a matter of what impression you convey. I know, since I practice in the Supreme Court regularly, I know that this kind of picture which is portrayed may not be fully accurate. But today, the common man must feel that, yes, there is a Supreme Court. If his rights are violated, he can go to the Supreme Court and get it vindicated. If he's arrested without any law, he files a habeas corpus petition. It's not adjourned by 8 weeks and 12 weeks. It is heard on priority basis. So all these things are really, really important. And the fact of the Supreme Court being polyvocal is because of the sheer number of cases. But that also carries with it the responsibility that all courts must convey a common impression. There should be a doctrinal cohesiveness that this is a Supreme Court which will not tolerate infringement of rights and which will really protect the citizens' rights. But I would simply say that it's not as gloom and doom as Pratap makes it out to be, but it is a lot of scope for improvement.
Gaurav, may I come in 1 second? Sorry.
Yes, of course. Yes, of course.
I mean, I hate to challenge Mr. Datar, but and I agree with him. And I think particularly the High Court level, there have been some extraordinary judges and judgments. But in a sense, right, what he's saying is in a sense exemplifying the problem. So one, the minute we start saying that jurisprudence is a matter of rule by individual judges, not by a court, we have already half conceded the point. Right? The second, and this I do want to highlight, I don't think the problem is polyvocality. See, polyvocality can work for accountability. Polyvocality can work for the fragmentation of power, which in itself acts as a check and balance. The issue is, despite this polyvocality, the Supreme Court has managed to produce a consistent direction in not preserving civil liberties. It has managed to produce a consistent direction that when it matters to the executive, it will not challenge it. So that's why the crisis is serious. Polyvocality, perfectly fine. A few bad eggs, perfectly fine. But it is actually the underlying authoritarian consistency of this court That is absolutely, absolutely astonishing.
Mr. Datar, I wanted to ask you about the public interest litigation jurisprudence, and there is criticism of judicial activism against the judiciary with respect to PILs, and I wanted to sort of ask for your views. Do you think that criticism is justified?
Well, I think one of India's contribution to world jurisprudence is this concept of public interest litigation. At any seminar, at any global conference, people are quite astonished at the kind of orders our courts are able to pass. And in fact, the PIL really highlights the topic which has been rightly chosen by Lord Goldsmith: who governs, government, parliament, or the judges? Now, this is the classic separation of powers from the time of Montesquieu, that there is an executive, there is a legislature, the judiciary. And the question is, who is supposed to govern, who is actually governing, or who is not governing? And that's where, in a sense, the PIL comes in. I have two things to say. I think, as once again, it's a mixed blessing. I would not say that PIL is a force of evil or it should be completely jettisoned. No, it has got its place. I know, for example, you take in 1979 when there was a series of articles in Indian Express, 40,000 under trials were released, were unlawfully detained. I know in my own case in Madras High Court, we had a very active green bench before the Green Tribunal came, and we were able to stop pollution in a number of cases. I know other high courts which have really supported human rights, environment, and PIL has been broadly based on either human rights or an environment in the initial stages. I think where it has gone out of hand and it has become really widespread in not all welcome ways is that we have not placed enough emphasis on the rule of locus standi. Who is the person coming to court? And if you read Justice Bhagwati's judgment in the first judge's case, he said that the PIL is meant, and I'll read what he said, the PIL is meant for, he said the PIL is a new method and a new strategy to provide access to justice to large masses of people who are denied basic human rights and to whom freedom and liberty is of no meaning. So basically, large masses of people who could not approach courts because of sheer poverty. And this was basically a writ petition, a class action writ petition, if I may say so, that you have a class action of a large number of, say, bonded laborers or under trials or people in remand homes and so on and so forth. This was the basic object of PIL. And I think it played a stellar role in controlling pollution. In fact, I would say that, for a large period of time, the entire forest of the country was managed by the Supreme Court. They were able to prevent large-scale deforestation through these laws. Illegal mining was checked by these PILs. But now what's happening is, it is going, I think, a bit too far. And I have, my personal view is there should be clear directions. In other words, there should be clear rules. As Pratap rightly mentioned, that you may have different number of courts, but if there's a clear principle, I should know that if I go to the court with this particular petition, these are my chances of success. These are the minimum standards I must qualify. You have a PIL recently filed saying that drop secularism and socialism from the Constitution. We have a PIL in one of the High Courts saying that nobody can access social media without an Aadhaar card. And it is entertained and it just goes into different directions. And what I think the first is the issue of locus. The other problem with the PIL is that courts are not equipped to pass orders which have got large-scale consequences. I mean, huge collateral consequences. Take, for example, this diesel cess. Now, as a student of law, I don't know what power a court has to say that impose diesel cess and apply it in this particular. It's a completely legislative function. It should not have been done at all. That's my personal opinion. Where is the power? Article 142 is there, but that doesn't allow you to legislate. Take the example of, say, for example, the BCCI matter. It started as a betting scandal, and then ultimately it went to a case where the Supreme Court virtually said that how the cricket administration should be there, what kind of constitution it should have, and so on. Which I thought is, in my personal opinion, not the role of the courts at all. And I can give any number of such examples where it has really gone out of hand. And I think it's now time to bring it back, lay down clear principles. As I said, I would prefer some practice directions or some clear norms that, first of all, who's the petitioner? Whose cause are you espousing? Is that person unable to come to court, number one? Secondly, if, as Lon Fuller said, that these are all polycentric disputes, when you simply ban diesel cars, you have huge implications. And I don't see why the Supreme Court of India should get into a question whether we should have BS3 standards of vehicle emission norms or BS6 standards entirely for Parliament to decide. So I think in some areas we should now make it very clear that court should not step in, particularly where there is extensive collateral damage that can be caused by court orders. And again, of course, PILs have been used to good effect, but I think it's a time for very, very deep introspection by all the courts and all the Supreme Court, and the Supreme Court especially. And we have clear norms throughout the country that these PILs are not to be entertained. And lastly, the other major problem in India is there is no system of costs. Whereas in UK, you file a case, you could be visited with heavy costs. Here, anybody can file a PIL, gives notice to the other side, the matter goes on for several weeks, then it is dismissed or it goes to Supreme Court. And who bears the costs? It will be a completely frivolous petition. So to answer your question, I think it's time for a reality check and a very, very close introspection on PILs with clear rules being laid down.
Thank you, sir. Professor Mehta, I was just thinking in the context of the concerns that you've expressed regarding courts being able to or not being able to satisfactorily protect civil liberties. I'm wondering, I mean, you've already expressed this in at least one public interview that I've come across. What do you think is the broader role of the legal profession in securing accountability of the judiciary? And I will then come back to a recent interview in which Mr. Nariman did express a view. Mr. Fali Nariman did express a view, and it was more in favor of being circumspect rather than being too over the sort of line on this.
So let me, because I'm going to say a couple of controversial things about the legal profession. Let me preface it by saying that academics are even worse, and in our case, the only saving grace is we don't even matter. So, these pathologies are less consequential. I think there are two things, and this is a longer term piece of historical sociology. Historically, in most democracies, lawyers and the legal profession has been at the vanguard of articulating a new and different kind of culture of rule of law and rights. And it was also true of our nationalist movement in some ways, right? Deep imprint in some senses of people with legal background. Right? Second, sociologically speaking, the legal profession, particularly the upper echelons of the legal profession, are typically the most protected, as it were, sections of the elite in any society. Indian business, I mean, the government has about 1,500 instruments in which it can silence them in 20 seconds, right? If you're a government employee or work in a state university, you do not have often that privilege of independence, right? And a lot of what will happen in courts will be a function of what are the kinds of cultural and professional norms that the highest echelons of the legal profession embed. See, the judiciary's legitimacy in the end depends on two things: integrity and the cogency of reasoning, right? I mean, it has no other, in some senses, power. Now, when the top echelons of the legal profession, right, and is not directed at particular individuals in some ways. And obviously in court, they have to sort of perform this. But when they institutionalize a culture, right, which in some senses makes short shrift of basic constitutional morality, understood in substantive terms, right? It in a sense legitimizes that broader culture of impunity one way or the other, right? And no other profession can take the kind of lead on this that the legal profession can do. Second, and this is true, by the way, that in terms of their effect on the court system, the senior legal counsel exercise a disproportionate effect on creating the legal culture, much more so than even Supreme Court judges do. In fact, if anything, I think most judges fear being in the bad books of senior counsel than the other way around, right? Now, the question is, in a sense, how do you use that cultural, intellectual, professional and economic power that you have, right? Do you use it to say that this is our collective responsibility to make sure that the legal profession institutionalizes norms that are worthy of this great constitution, right? Or do you use it to say, look, anything goes, right? The problem right now, in a sense, and this is the disagreement with, I think, Mr. Nariman. I think maybe it's a generational thing. Maybe we are just young and hot-headed, and is the kind of restraint that he's talking about would be appropriate if the norms were actually working. When the Supreme Court is the culprit and the legal profession doesn't speak out, right? The alternative is going to be even worse. I mean, it is then going to be decided by mobs in some, in some ways, right? When the legal profession itself does not display in public, as an exercise of public reason, obviously in courts they have to take particular sides, display a commitment to basic constitutional norms, right? Where is Pakistan's legal profession was much more active in combating a executive overreach than the mightiest legal profession in the world, which is the Indian legal profession, has been, right? When the Indian legal profession teaches in public that under National Security Act, any form of impunity is licensed or justified, right? That damages faith in the rule of law even more than an occasional errant judgment does. And historically, as I said, no democracy has grown without the integrity of the legal profession. That's the critical piece in this.
Lord Goldsmith, I was wondering if you had a perspective on that issue from the English bar perspective. And I then wanted you to comment on another question, whether you think that there should be a written constitution in the UK.
Well, let me say first of all, it is wonderful listening to this debate. It's tremendous. I feel a little bit like an outsider coming into a family house and listening to a wonderful debate, but still a very sharp and polarized debate between members of the family. Professor Mehta said the words which I always watch out for, which is, I'm not a lawyer, but, and I've heard that so many times in my political and legal life, and I know what comes after the but always is very, very powerful. And listening to what he said, it is powerful, indeed. And I think that the key point is that, and this is really what this debate is about, is precisely the question of where the power is. Now, I'd thought when we set up this debate, it was going to be between the judges, Parliament, and the executive. I hadn't expected it was going to be, we're going to add the lawyers into it as well. That's a very, but I see the force of the argument that's there. And it demonstrates two things. We've seen this a couple of times during this debate. One is, surprisingly, the power of procedure as opposed to substance. So can you get the time to have a debate in Parliament? If you can't, the fact that Parliament governs doesn't really help you. We do have this problem in the UK as well, that we find ways to deal with it. In the Brexit debate, we actually found ways to get parliamentary time to pass opposition laws to force the government to ask for an extension through changing the standing orders. But that had to be done using a majority too. If we haven't had a majority, that is to say, of the opposition parties and a number of governments supporting MPs, particularly, we wouldn't have succeeded. It's also in relation to the way that the law operates. I mean, I was interested in the discussion about public interest litigation. I've always admired that as a way of having people in a huge country with people with huge problems and limited resources to advance their interests to deal with that. Wonderful. But of course it does have an impact on the sort of issues that are then decided. And I've always, I'm not going to say admired, but certainly found remarkable the extent of the powers that the Supreme Court operates. But still, it does a tremendous job. I think that having people in a huge, I think that, but the particular point I think is, power abhors a vacuum, which is a misquotation of a scientific rule. And the result is, if somebody is not acting, then someone else will come in to do it. And the government in the UK, the government's rule and motto for Brexit was to take back control. We all thought what they meant was take back control for Parliament. It then turned out what they really meant was take back control for the executive, which is not, I think, what people had voted for. So it shows how you have to be very clear who is actually supposed to be in control. Now, does a written constitution help? Everyone says the UK has no constitution. We do, in a sense, have a constitution. I mentioned before the Bill of Rights 1689, which I suppose was the first bit of a written constitution. We have the Human Rights Act, is also sort of a constitutional document. We did toy with the idea during Gordon Brown's premiership of having a written constitution, but in the end, it's so difficult to write, so time-consuming to try and get agreement on it that people sort of gave the idea up. Would it make a difference? I'm not sure. Ultimately, you have so many exceptions, you have so many differences that you could probably find your way through it. So I'm going to quote again what Professor Mehta said, use the other phrase that I always find wonderful, which is with all due respect, which, as any judge will tell you, means with no respect at all. And I thought his demolition of the legal profession was very effective. I'm sure Mr. Datar will come back and disprove him, but I'm just glad it hasn't been directed against my legal profession too.
Yeah, I want to ask, Gaurav, can I ask Lord Goldsmith a small question? Do you have any illustrated instances in the UK where the judiciary has been accused of activism and has gone into the area of the executive?
The Brexit, yes. I mean, the Brexit decisions did. You know, that was said. Human rights, it has too. So when three of our most senior judges, not from the House of Lords or Supreme Court, but the Court of Appeal, made a decision in relation to Brexit, they were accused of being enemies of the people in the newspapers. So they have done. Whether it's justifiably is a completely different matter. But the accusation has certainly been made. When I was Attorney General, I remember there was a case in which it was about detention of terrorists, in which I said...
The Belmarsh case.
Yes, the Belmarsh case, in which I submitted to the House of Lords, as it then was, that they should not interfere with the decision of the executive because they didn't have democratic legitimacy. I got really torn off a strip by Lord Bingham, who was presiding over the House of Lords, and I got one vote in my favour, and all the rest voted against me. So that was an example, I suppose, of an allegation of judicial activism by the government, in that case represented by me, which didn't succeed.
So Pallavi's here, and she had some live questions to put to the panelists. But before that, I wanted to give just 1 minute to Mr. Datar, if he wants to respond to Mr. Pratabhanu Mehta's comment about how he finds the legal profession, particularly us, you and me, senior advocates, deficient in terms of standing up to, in terms of holding the judiciary accountable.
Well, I think we must take his criticism very seriously. A large part of it is justified. And as a member of the editorial board of the SCC, we hardly get any kind of articles criticizing judgments or analyzing judgments and so on and so forth. That's a very, very big drawback in our system, where I think most senior lawyers like us should write about the articles, write about judgments which are wrong, which we think are not correct constitutionally, and at least say those things. You see, so and at least as far as lawyers, we are at least confident that there is no question of any contempt against us. We may have a legitimate criticism. For example, against this decision on Kashmir not to extend the internet, you could have two views. I mean, one must respect the judgment when it says that they're leaving the executive. I wrote an article criticizing it, but then habeas corpus has been postponed by 8 weeks and 10 weeks. It's contrary to basic principles, according to me. But then there should be some discussion. The legal profession must come out and say that, look, this is not on, this is not done. Habeas corpus must get priority. And once you say that people of a particular state are just like others, then why should they be denied the internet? So these are all things which we should have taken up much more seriously. And just me writing or you writing is not enough. I think the legal community as such must take it up very seriously. So I think what he said was perfectly justified, and we should really think about it and mend our ways.
Very well, sir. Pallavi, you had some questions. Please, could you address them?
Yeah. So thank you so much, panelists. But after hearing Mr. Pratabhanu Mehta and Mr. Datar, I have changed The order of my question. My second question is first now. Contempt of courts is often a weapon used by courts to threaten, but hardly ever fired upon. One of the finest examples from UK is the Lord Templeman's judgment, which is quoted in all editorials in India. What do we have to learn from that, or do we have anything to learn from the UK?
I think Pratap can answer that.
Lord Goldsmith, I think.
Lord Goldsmith can perhaps speak on contempt, because we're talking about, are you talking about the three old fools, that judgment about the three old fools, where they show the people, the three law lords in the reverse fashion? Yes.
Yeah.
And yes. On contempt law, they wanted your reaction at the UK's observation on contempt, where they're very, very reluctant to take any action on contempt.
Absolutely, we don't really use contempt in that way. I mean, one of my responsibilities as Attorney General was to apply the contempt laws, and in relation to things which might affect how a jury reaches a decision, like publishing information which could be prejudicial to a defendant before his trial has taken place, we'd be quite strict on that. In relation to people criticizing judges, on the whole, we took the view that the judges had thick skins or broad backs and were able to take the criticism. Of course, it's not completely true, because the judges sort of can't answer back. So it would be the role of the Lord Chancellor of the time actually to stand up and defend the judges. And occasionally, when my political colleagues, my colleagues in the cabinet, were criticizing judicial decisions, I would say to them, don't do that in public. They can't really respond. If you want to criticize it, I'll take that case to appeal, and then I can argue before a higher court the objective reasons why that particular decision was wrong, and we'll see where we get to. They never liked it very much, but on the whole, they fell in line.
Yeah. Pratap, would you like to answer that on content?
No, I mean, you're better equipped to answer it on technically.
Yes. Now, of course, I know in what context she's asked this question, because currently there's been a notice to one of our colleagues. But, you know, as a student of constitutional law, I think that with due respect, to borrow Lord Goldsmith's thing, with due respect, I don't think the Supreme Court has been consistent in contempt law. If you take the past, we had a former chief minister called E.M.S. Nambudripad. He was a Marxist chief minister, and he made the most damning accusations of the Supreme Court, of the judges, in fact, and he said that these are all class enemies, and they support the bourgeois and so on and so forth. Very, very strong statements. And ultimately, the Supreme Court levied a fine of some 50 rupees and said that, ironically said that he doesn't know Marxism, which is very, very strange that you tell dyed-in-the-wool Marxist that he doesn't understand Engels and Marx. Then Shiv Shankar, the law minister, he made some very, very extremely strong remarks about the judiciary, yet he was exonerated. So time and time again, they've not had a uniform principle as far as contempt is concerned. But take Arundhati Roy. She was punished for something which I don't think should have been punished at all. And I personally feel that overusing the contempt jurisdiction is actually counterproductive. You know, it's really, really counterproductive. And it damages the institution more than the person who is alleged to have committed contempt. The point is, as Lord Atkin famously said, it's not a cloistered virtue. Lord Denning said that we get our real worth from the quality of our judgments and so on. And that is true. I mean, if your judgments, as Pratap said, are cogent, they are well-reasoned, they support human rights, you're really discharging your constitutional function, then it's a judiciary which all of us look up to. And then we will definitely have, be very careful in what we say. But when a person says something, there's no point simply issuing a contempt notice. I think it's also time to introspect for the judiciary to introspect why are so many criticisms made against the courts? Is something going wrong in our system? Are we not living up to what the people think? Because ultimately, it's all about perception. People must feel that we have a strong judiciary which will protect our rights, and that is the most important thing. So I think I
think we lost Mr. Datar.
I think we lost Mr. Datar. Yeah. Pallavi, could you?
I must just close with. I had the privilege of briefing Mr. Parasaran's father, Mr. Parasaran, who's 94 now. I had the occasion of briefing his father, who was 93 years old when I briefed him in 1993. And he told me that the contempt jurisdiction is an anachronism in a Republican democracy. He said we should not have the contempt jurisdiction at all. He traced the history of the law of contempt and said there's no contempt in Roman law and we should not have it at all. I don't agree with that view. Contempt has got its place, especially to enforce obedience of a court's order. But then to use contempt to check any kind of criticism, I think is not a step in the right direction. Just let people criticize, and if it's true, then you make changes. If it's not true, then you've got other remedies.
Thank you. And I have one more question. Although each of these organs, government, parliament, and judiciary, are independent under the Constitution, and yet having some degree of interdependency and oversight, what is the ideal balance that we need to strive? Are these examples of ideal balance, or sorry, are there examples of ideal balance, or are we just a chaotic democracy where we set standards as we govern?
I think Pratap can answer that.
Oh gosh, that's an important, very big question. I mean, I think just two quick thoughts. I think it's not, obviously this requires a fuller answer. So one, I think in a democracy, I think Ambedkar said it actually very powerfully. And in that sense, our understanding was sort of a little bit different from the traditional British understanding of parliamentary support, which is, there is no unique locus of sovereignty. The people exercise their power through different organs of government. So we have to co-produce governance and we have to co-produce constitutional values, the judiciary, parliament, and so forth, all working, right? And that's why there is a kind of inherent ambiguity in some senses, right? Parliament can pass legislation, judiciary can strike it down, parliament can override it, judiciary can invoke the basic structure. So far, we haven't reached a point where Parliament has thought it fit to rebel against that. And if that is indeed the case, the good old-fashioned argument, in the separation of powers is that you need both moderation and dialogue, right? That there will be gray areas, right, where the different branches collide, overlap. There is a difference of interpretation. And the question is, what are the reflexive feedback engagement loops, not necessarily always formal, but informal, right? By which those rough areas can in some senses be ironed out. I think right now what's in a sense been happening, I mean, it's like almost like a competition of jurisdictions, right? Whose turf is it important to protect? Rather than a slightly different question, how do we collectively co-produce the constitutional values that in some senses we want to, And one of the consequences of this is that there are too many, you might say, corner solutions, either ors, right? Either it is this person's discretion or not that person's discretion. Yes, it can be their discretion, but it can still be subject to a reasonable exercise of public reason, right? So ultimately, and if we think the Constitution can be saved by one branch of government, then we are already in trouble.
I have one very interesting question, and I will put it to Mr. Datar before I come back and ask the last question for today's webinar. I'm sorry, I couldn't take the name down, but the question is, do you think that the exercise of PIL jurisdiction sometimes results in substitution of mere opinions of judges not supported by substance?
Yes, it does. It does, because very often what happens, you see, for example, I'll give you a common example. Today, we talked about the collegium system. Now there is a process where names are recommended and then the appointment takes place. And there is a problem that there is no time limit. There are appointments of High Court judges, appointment of Chief Justice, appointment of Supreme Court judges. And in some areas, there is no time limit for an appointment. We moved a PIL from the Madras Bar Association saying that the court should, since you have formed a collegium system, it's through a judicial order, you also laid on norms saying that, look, there should be 8 weeks or 12 weeks to make the approval of a particular process. And that was dismissed by one bench as saying, no, we're not going to interfere despite notice being just a few months later, another bench has issued notice saying it's a very, very important question. So it's a matter of perception of an individual bench. One bench thought it was didn't merit consideration at all. Another bench thought it was very, very important. And you're right, sometimes, very often it depends upon who is the portfolio judge for the PL in a particular place. Some judges are more proactive. They want to get into the arena, pass directions and so on and so forth. Other judges are not so. Yes, but it could a lot depend on the individual perception.
So the last question for today, and I would address that to Lord Goldsmith first, but I would then request each one of you to comment on it in 1 minute to 1.5 minutes if possible. So what is the answer in a democracy? Who governs? Is it government, parliament, or the judges?
Well, of course, the correct legal answer is all of them in different ways at different times working together. But that doesn't tell the whole story of what the political reality is. I mean, I'll just give you one example. Our Human Rights Act, which, contrary to many people's view, is not affected directly by Brexit. The Human Rights Act, which implements the European Convention on Human Rights, does remain in force and will remain in force after Brexit has been completed. But what it does do is say that if the courts reach the view that a particular piece of legislation is contrary to the principles of human rights contained in the European Convention, they don't strike it down. They make a declaration of what is called a declaration of incompatibility, which triggers the possibility of fast-track parliamentary procedure to change it, but doesn't invalidate that particular law at all. Now, that was a way of trying to find a balance between having objective, judicial-led criticism of laws without actually taking away from Parliament the ability to decide those issues. Because, as has been said in several cases, there certainly are areas where it is for Parliament, who are elected by the people, who are carrying out the people's will, to exercise. I've just got a questionnaire asking me what I thought of the seminar so far. I thought, not sure it's for me to say at the moment, but under our system, the legislature can always overrule whatever everyone else does. That's the principle of parliamentary sovereignty. And once we've left the European Union, nobody will be able to stop that. But that doesn't mean that the other, and that means it's Parliament working with the executive which governs. But the courts will continue to have an important role in holding the government to account, in helping Parliament to hold the executive to account. And only if all those work together are we likely to have a fair society in which individual grievances can properly be ventilated and I hope acted on. But there will be a role for lawyers, there'll be a role for judges, and I hope there will still be a role for politicians too.
Mr. Datar, your views on the last question.
You see, in an ideal situation, it would be a classic situation where the executive does what it has to do, that is to implement the law, Parliament makes the law, and the judge interprets the law. That would be the classic theoretical model. But as you know, that life is not perfect. And there's bound to be overlap. Right from 1955, our Supreme Court has said that there is no strict separation of powers. There's going to be some amount of overlap. But I think by and large, if the executive sticks to implementing the law and Parliament takes its role seriously, I find one major problem is the bills are said, they're not debated often enough. They are simply pushed through Parliament, which is not a very healthy sign. So if Parliament does its duty, what it has to do, it would be a wonderful thing. Then the executive has to implement the law. And of course, if the judges primarily stick to the adjudicatory function, stick to deciding cases, and only in rare cases get into PIs and so on, so it'll be a wonderful idea. But at the heart of it all, I mean, in any country, whether it's India or anybody else, this question of this separation of powers and each role functioning will ultimately depend upon the leaders. And I find that if the leaders are of the stature of politicians, you're bound to have problems. It's only when the leaders reach a higher level of statesmanship that you'll have true and effective method of implementing this separation of powers. So what we require are statesmen if we have to get this thing done.
So in some way, I was thinking whether the question who governs is answered really by the answer as to who is not governing, in the sense that who ultimately governs might depend on which branch of government is not fully discharging its function. And that is the space that it secedes to to the other branch. Mr. Mehta, Professor Mehta, your comments.
It's hard to add to this. Look, I mean, we call ourselves a constitutional representative democracy. And I think we need to take all three of those terms seriously. Constitutionalism, but not just as a preserve of the judiciary. Ultimately, all of us are collectively custodians of the idea that there are certain baseline values which define our social contract. Representative, which was one of the great inventions, as it were, of modern government, the idea that democracy can function through the role of representatives. And if we reflect upon what representation means in all its dimensions and all its scale, frankly, I mean, I think it's not just parliament, it's state legislators, where the function of representation has become even more decimated than it has at the level of central parliament. And then fundamentally democracy, I mean, which is that, yes, the sovereign has to sleep most of the time for democracy to effectively function. But in times of crisis and once in a while, it has to wake up and mobilize so that the representatives get the right kind of incentives and pressure to know what they're supposed to be doing to express our will in all its inchoate forms.
Gaurav, why don't you have the last word? You are our panelist as well. So who governs?
So as I said, I personally believe that in a changing polity and in a changing society, really, we have, in a representative democracy, we have conferred these three functions or three branches of government. And while in an ideal scenario, it has to be a cohesive model of governance, there will be situations where one will do more than the other. And of course, once that happens, there will be concerns regarding overreach. But the answer, the situation in which one does more than the other will be a result of who is not doing what it is expected to do. So the answer of who governs has to be as to who is not governing, in my view.
Can I just ask Gaurav this?
Yes.
Would your answer be the same if you were sitting in the United States at the moment, answering that question?
Shall I say that United States as of today is a unique place to comment upon? There are no paradigms that apply to United States as of today. I was saying this more in the context of the evolution of our own democracy. I think, to be very honest, the problems of governance or the issues of governance that emerge both in the United Kingdom and in the United States are peculiar to those jurisdictions, and the ones that we now see in India and are commenting upon are, in my view, a result of who is not really, which branch is not really discharging its functions fully. Pallavi?
I would like to ask what Lord Goldsmith thinks. Whom does he think governs in the US?
Well, it's obvious that the President Trump governs until he's stopped.
Yes.
Whether that's individually or I suppose in an election, provided it's not pushed back. But I think it's interesting because remember that the US Constitution was supposedly based on a perfect democracy that had been looked at, had been analysed by Montesquieu coming from the British system, and he thought it was a perfect separation of powers. And I think if one sees the way that the US democracy works, one can question how perfect it is, though ultimately it does operate, I suppose.
Yes. And I think we can perhaps judge the US only by Trump, Perhaps he's an aberration. It's not happened in the past so often. Yes.
Well, we'll see if it's going to happen again.
I think we will have to come back to part two. Pallavi, sorry, I interrupted you.
No, go ahead.
No, I was just saying that I think we will have to come to part two of this discussion because there are so many questions from the panelists that I have not been able to take. And there are from the participants, from the registrants that I have not been able to take. And there are so many questions that I had in a list for the panelists that I have not been able to put. But Pallavi, I wanted you to give the concluding remarks and then we could wind up because we are already
thank you so much. It was an enlightening session. I wish we had more time. We have a lot of attendees who've asked questions, but maybe that's for the next time. Thank you.
I mean, if there's important questions, you can send them to us. We can email to them. A very important question.
We can
Thank
do
you.
that.
I mean,
Yeah.
Yeah, they should, because of shortage of time,
Yeah.
having attended the conference, if they've got some interesting questions, we could really answer them.
Thank you.
They're wonderful questions. I've been reading some of them. Thanks to all the participants and Pallavi and particularly Gaurav for sort of very patiently putting all of this together. And of course, it's always a great privilege to hear Mr. Datar and Lord Goldsmith. Thank you.
And I must thank Pallavi and Akshay of Lex Witness and Bar and Bench for doing all to make this successful. We had a very large number of participants. And thank you, Lord Goldsmith, for taking time despite being in France at this time.
I want to just say, like a third member of a court of appeal, I agree and have nothing to add.
Thank you so much.
Thank you very much.
Thank you.